They're also now live streaming.
All right, good morning. I'm Beth Mitchell. I'm the president of the Arkansas State Board of Pharmacy. Call this meeting to order. It is 9:03 on Thursday, October the 14th. Present here in the board office, we have board members Dr. Lenore Newsom, Dr. Brian Jolly, and joining us remotely, we have board members Dr. Lynn Krause, Ms. Carol Rader, Dr. Debbie Mack, Ms. Amy Moore, and Dr. Rodney Richmond. I'm going to turn the meeting over to our hearing officer.
All right, good morning, everybody. So we're just gonna roll right into the first. You said Mr. Johnson's here?
Yes, I believe so. Mr. Johnson, are you on? Will you turn your mic on and turn your video on so we can see you? Great, thank you.
Hey, good morning, Mr. Johnson. So we're here today. This is an administrative hearing before Arkansas State Board of Pharmacy. It's Thursday, October 14th, a little after 9 a.m. We're at 322 South Main Street, 600 Little Arkansas. And this is a case in the matter of Mr. Spencer Johnson, case number 2021-CE-029. So the board set a hearing today concerning the matter specified in the notice of hearing. My name is Jake Jones. I'm an attorney and I'll serve as the hearing officer in this matter. And Mr. Johnson, I see that you're present. Could you introduce yourself for the record, please?
You're muted, Mr. Johnson, if you want to mute yourself, we can't hear you.
Sorry about that. My name is Spencer Johnson. I am a pharmacist out of Murray or Salt Lake City, Utah. I've been practicing since 2012. I obtained my Arkansas license a few years ago as part of a mail order pharmacy. I'd like to keep my license with Arkansas. And
Okay, all right.
thank you.
And so did you receive a copy of the order and the notice of hearing?
Yes, I did.
Okay. Ms. Daniel, can you introduce yourself for the record, please?
Luke Daniel, the General Counsel, Arkansas State Board of Pharmacy.
All right, Ms. Johnson, at the outset of this hearing, I'll explain some things, how it's going to flow for your benefit. If you have any questions, let me know. But so the board will base this decision today solely on what's the evidence that's presented today. So any testimony or any documents that you have that you want to submit. But make sure that you submit those things because otherwise the board won't, don't assume that the board has it. If you have anything that you want to send in, make sure you send it in.
Okay.
Then this hearing is done under the Arkansas Administrative Procedures Act. So like the rules of evidence don't necessarily, the strict rules of evidence don't apply. If it's relevant, it gets to come in. So, hearsay or photocopies of documents, all that stuff will get to come in. We have a court reporter, Ms. Tiffany Harrison, so everything that we say, that she's taking it down, she's making a record of this, so, speak slowly and distinctly and try not to talk over anybody. And again, the board themselves, they don't know anything about the case except what's in the order and notice of hearing. So anything that you want to present, anything you want them to consider, make sure you get it out of the hearing today. The hearing is open to the public, and so, it's being recorded. And what's kind of weird about this is that when we go off the record for the board to deliberate, no one leaves the room, you don't have to leave, you'll be able to hear them, you'll hear the board deliberating, but you can't break in and interject anything at that point. Like I said, it's just kind of weird, they're deliberating in front of us, but if there's something that you want to clarify, or, we can go back on the record, open the record up, and you can do that. So anybody that's going to be a witness today, if they be sworn by the court reporter and Dr. Spencer, I guess you just have, you'll raise your right hand if you're your only witness today.
Okay.
You solemnly swear or affirm testimony you're about to give that will be the truth, whole truth, and nothing but the truth?
I do.
Yes.
All right. Mr. Daniel, any preliminary matters, anything you want
We would just ask you to take judicial notice of Arkansas statutory law and the pharmacy board rules and regulations. And we move to enter exhibits 1 through 4 at this time. I have no copy to Dr. Johnson.
to, okay, notice will be taken of the statutes and regs. Ms. Johnson, or Dr. Johnson, you had a chance to look at the exhibits the state's going to introduce today?
Yes.
Do you have an objection to any of those documents being considered by the board?
No.
Okay, all right, well, those documents will be entered into evidence. All right, Ms. Daniel, you ready to proceed?
I am.
Dr. Spencer, are you ready to proceed?
Yes.
All right. You can make an opening statement if you want. You don't have to, but an opening statement is just sort of a roadmap to, kind of tell the board what you expect to show them today. But you don't have to make an opening statement. Ms. Daniel, do you want to make an opening statement?
No, sir.
All right. How about you, Dr. Johnson?
I'd be happy just to share a couple things. When I received the notice that I was short of CE credits, I was certain that I had the appropriate amount of CE credits. At the time, I was experiencing COVID and long haul COVID, and was struggling to do day-to-day functions. So it took me some time, and I was unfortunately unable to find the appropriate documentations stating that I actually did the required CEs. So at this time, I hope to do what I need to do to make amends so that I could keep my Arkansas license. And in good faith, I have completed the CE credits for the upcoming cycle.
All right. With that, Ms. Daniel, you can call your first witness.
Thank you, Mr. Jones. State Health Deputy Director, Brandon McCready. Dr. McCready, I guess it was back in 2020, the board conducted a CE audit, is that correct?
That's correct.
And when you just kind of walk through, just be very brief, just what that audit entails.
Basically, the audit entails pulling documents from the CPE monitor, as well as any CE that we have that may not be ACP accredited. We send a letter out to pharmacists that we audit. Once we send that letter out, it tells them that we don't show they've met their hours, but they please provide any documentation proving those hours that they've met. Oftentimes, we may have 25 hours in the monitor, and there's 5 hours that they attended that was maybe a category 1, or it may be some other CPE that we accept, and they'll send that in. Once I get that, I'll verify that they have met the requirements, and I'll check them off. Normally, the biggest portion of people get that back into us. Sometimes they don't. If I don't receive it by a certain deadline, then I'll send out a certified letter stating that I've not received this, that we show you're 2.5 hours short, you have an extension to whatever deadline, and then at that point, we'll send a consent agreement that says we show that you are an hour short on your non-live CE, and the board has ruled that there should be a $100 fine per hour plus twice the amount of CE. So we'll send that agreement out. If they agree to that and sign the consent agreement, just mail us a check, send us in the CE that they've done, and we close it out. And in some cases, for whatever reason, we have some that don't respond, and then we end up having to come before the board with it.
Thank you. I apologize for that. So most of these, the vast majority of these are resolved. Either they get it sent in, it's just not in the computer or something like that.
That's correct.
And so, Dr. Spencer got one, Dr. Johnson got one of these original letters.
Yeah.
So, and then he got a second certified letter, and then he got a proposed consent agreement. Was he trying to contact after that?
I have made numerous attempts to contact him. I actually looked up in the state where he's licensed and looked up where he worked. I've sent letters to both his home address and his work address. He did actually contact me not too long ago, and I told him that at this point it was already set before the board and that it would have to be resolved.
That was within the last couple of weeks.
That was just the last couple of weeks.
So that's the first time. So this started, I mean, this audit started probably about summer of 2020.
Normally it takes, we don't get, all the renewal and everything is actually finalized till April 30th of the year after the renewal. So if they renewed by December 31st of 19, then we received the documents, started receiving documents at the end of April, 1st of May. So we actually would have started that audit probably in the middle of May to the 1st of June.
Okay, so this was, I mean, year and a half later, pretty
Yes,
sure.
sir.
And the first time, and after all those letters from certified emails, first contact you had with him, the first time he contacted the board was within the last couple of weeks.
Yes, sir, that's right.
And I'm looking at the, and you have exhibit 4 is his CPE, the monitor report. Is that correct?
It is, oftentimes if I don't hear from the pharmacist, I try to give them the benefit of the doubt and I'll go out and into CPE monitor and actually look them up by their license number and pull out whatever CE they have, which is actually not something that I have to do, but I try to give them the benefit of the doubt that maybe it's there, I didn't get it. So I'll go out and pull that and print it, and that's the hours I go by if I haven't had any contact.
Okay, and this shows how many hours?
It shows 14.25 live and 14.5 non-live or home hours, for a total of 28.75, which makes them 1.25 hours short of non-live sleep.
Okay, and I know the board members know this, just for the record purposes, what are the hours that are required for pharmacy license?
Arkansas law requires that pharmacists have 12 hours of live CE, 12 hours of ACP hours, which the chief can be the same, and then the balance in whatever kind of hours they'd like to get.
But for a total of
For a
30,
total of 30 hours.
every 2 years, during the 2-year license period.
And we are required, the Arkansas law does require pharmacists to maintain their records for 4 years from the date of receipt. So that gives us time to be able to offer that.
Okay, so he was 1.25 hours short.
Yes, sir.
And about how many, and I know this can get time consuming, especially when it gets to this point, so about how many hours of work
I would
per
say
person?
about 5 hours per person.
I know, further, thank you, Mr. Good.
All right, Dr. Johnson, do you have any questions for this witness?
No.
Okay, board members, do you have any questions of Dr. McCray?
I have a question.
All right,
Dr. McCray, you said you offer an extension. So how long do you offer?
Well, when we send out a consent agreement, I think there's a copy in here, one of the exhibits, and I normally give them 30 days, and then I'll contact them. Once that happens, if I don't hear from them, then we'll send a consent agreement. And this consent agreement actually gave them it's actually a consent agreement.
It is not.
Normally, the consent agreement will give them 30 days to send it in, and then they have some time to pay the fine and get the hours.
Right. So you're offering an extension, and you're asking for twice the number of hours that they're short, and $100 fine
Per hour.
per hour, and then provide you with documentation. So,
And then it's non-disciplinary, it just basically goes on.
I'm sorry, you said 5 hours per.
It takes quite a lot of time, but about 5 hours when you have to continue to send them letters and do certifications and search for deliveries and that. It takes about 5 hours.
all right. Any other board members have any questions of this witness? All right. Dr. Richmond?
I'm having a little bit of trouble hearing, so this may have already been said, but has Dr. Spencer ever had any other action taken against his license, at least in Arkansas, that we're aware?
Not that I'm aware of.
Thank you.
All right, any other questions?
Dr. Ross.
I was just wondering how long, Dr. McCready could tell us about how long how much time did she spend on this?
It takes about 5 hours a person when you have to search, see if it's been delivered, send them consent agreements, give them extensions, try to contact them. So I would say just about 5 hours a person.
All right, Dr. Mack.
Thank you. I didn't know if you could see me. Dr. McCready, is he here at the board meeting because he didn't want to take the consent order and pay the fine, or is it because we didn't ever hear from him?
We did not get any response from him at all until a couple of weeks ago. When he called, he did say that he'd been out with COVID and had some issues, but we had no response at all. So that's when he was scheduled for. He's been licensed with us for several years, and I don't recall ever having that issue before.
I just looked over his, he has no action showing on his license hour.
All right, any more questions from the board?
Well, we were charging him the per hour of CE that he didn't do. What did the consent actually say? Sorry.
It was for $125 and 2.5 hours of makeup. So
Okay.
it was short, an hour and, like I said, an hour and a quarter. So it would have been $125 and 2.5 hours of makeup on top of the 30 that would be due for this renewal period.
Right.
Dr. Jolly, you were looking at figures on the end that the staff that's been on this case. Would you take a conclusion on that, sir?
That would be if we utilize $75 an hour, it would be $375
Okay,
for investigative costs.
thank you.
The 1.25 that he was short, was any of it short because it wasn't live or it wasn't ACP credit, or you really could he have gotten anything like just any type of CD?
He had 14.25 live hours and 28.75 ACP according to our records.
Dr. Richmond?
And did I understand that Dr. Johnson said he has already completed hours for the, he made a statement that he had completed some other hours. What was that?
Sorry, for
Go ahead, I don't mind, Mr. Jones, we can turn it over to Dr. Spencer again.
Okay.
All right. Well, so, okay, all right, you're done. No more witnesses, state rest. Okay, Dr. Spencer, it'll be I keep calling Dr. Spencer, Dr. Johnson. It'll be your case now, but I think the board, it's kind of out of order, but the board wants to ask you some questions, but you can testify, you've been sworn and everything, so.
Let him testify and then maybe we'll answer the questions
Okay.
during his testimony.
All right. Okay, so at this point, Dr. Johnson, you can testify about, tell the board what happened.
Okay, I previously I was working at a hospital plus 2 different pharmacies. So I had to do CE through a bunch of different means. And so I was trying to keep track of multiple CE credit opportunities. Somewhere along the line, whether it was lost due to when the COVID hit and they shut down there's a lot less work at the hospitals. I lost my hospital job. I believe that with that, I lost my hospital, what's that called? My hospital email. And I think with it, I lost the documentation of the extra CEs that I had taken. So that's where I believe where the missing documentation and CEs went when I no longer became employed there. And like I was saying earlier, I had COVID earlier this year, and I was unable to work for some time, and it was really difficult to just do the day-to-day tasks. And I had lost the original documentation, and that also contributed to the delay. Kind of a sorry excuse, but at this point, I've done the CE required for the upcoming licensing cycle. In addition, I've done extra so many hours in good faith, hoping that we'll be able to move past this, and I'll be able to retain my Arkansas license.
All right. Daniel,
No questions.
no question. All right, board, you can ask Dr. Johnson now if you have any questions for him.
Dr. Richmond, did your question get answered?
Yes, it did. What I understand him to say is he has already worked ahead and got his CE hours for this renewal period that's upcoming.
But would he need to supply some of that to Dr. McCready, or is it going to be in the CPE monitor?
Let me send those.
It is in the CE monitor, but I'd be happy to send that to whoever you would like me to.
If you could send them in, that way we can document which hours you use, because you can't use them again for your renewal. Those will be in addition to your other 30 hours you have to have this December.
And Dr. Johnson, I would assume that the hours that you say that you thought you had in your email but were lost, those were non-ACPE hours. Is that correct?
I am not sure. I remember that they were, I was trying to get my NEBP number locked into the system, and I can't remember if it had registered with the software that was being used to record those hours. I remember there was some difficulty with that, but like I said, I've since lost access to that email, so I no longer have that information.
Thank you.
Oh, Dr. Mack, thank you.
I just have one more thought. Dr. McCready, so just to make sure he's aware of what he needs, how many hours did he need to supply you for last year? Of course, 30 plus, or how many hours should he at this point supply for last year? And then he can determine if he's actually got enough for this year. But how many would you need him to supply you?
For the last renewal and to bring yourself current, he would need to provide 2.5 hours, which is twice the amount that he missed, plus his 30 hours, 12 live, 12 ACE that are due this December, for a total of 32.5.
Thank you.
I believe I have over 36 hours at this point.
Dr. Johnson, you said you lost your hospital job. Was that your primary job?
No, that was not my primary job.
And you're gainfully employed now currently?
Yes, that's true.
And Dr. Johnson, just to make sure you have the proper mix of ACPE, proper mix of live for this current year in that 36 hours.
Yes, I have over, I believe I have, sorry, I'm not able to pull it up while I'm on the Zoom meeting. I know that for the Utah licensing cycle, I was required to have 15, and I was able to meet that.
Okay, any further questions from board members? Mr. Daniel, any questions?
No, sir.
All right, Dr. Johnson, anything further? And I'll give y'all a chance to just sort of make closing statements in a minute, just tell the board how you'd like to see the case come out. But any further evidence to offer at this point?
No, thank you.
Okay, all right, well, at this point, Mr. Daniel, if you have a closing statement you want to make, you can.
Just real quick, we would just ask that, this be, that he be ordered to pay $125 for the $100 an hour, that he is short. We ask that he be ordered to turn in an additional 2.5 hours of CE by the end of the year. And we ask for $375 in investigative costs. I know this is more of a paperwork issue. Don't want him, I mean, as he's out of state, apparently has licenses in other states, would ask that it not be disciplinary. I mean, this is not I think we still have to file this order because it came before hearing, but we would ask that it not be disciplinary. Just, I mean, this is, yes, I mean, granted, he should have kept his contact information up with us. He should have, taken that effort to do that. But we're not, I mean, this is not somebody's life in danger. This is not something I'm just keeping care of on his behalf. I mean, on his part, I guess. So anyway, we would just ask that, like I said, it appears he's licensed at least in other states. So that's what we would ask. $125, 2.5 hours, and additional $375 for investigative costs.
All right, Dr. Johnson, you can tell the board now how you'd like to see the case come out by way of a closing statement.
I'd be happy to pay a fee and comply with the extra hours as outlined. And I'd like to retain my Arkansas license. Thank you very much.
All right, so closing statements have been had. Before the board goes off record to deliberate, any questions of, you want to ask your counsel?
In order to prevent this from potentially being reported to the National Practitioner Database and affecting other permits, is it possible at this point to take no action and rescind him another consent decree?
That's what I have no issue with that. If that's what you want to make, I mean, if that's the decision you want to make today, yes.
I'm not sure if that is going to be the will of the board. I was just trying to find out if legally that's an option.
Yes, you can.
You repeat that?
You can actually vote to dismiss these charges and offer him a consent agreement, which he's pretty much already said that he would pay. So yes, I would use the words, if that's the motion you want to make, or somebody wants to make, I would use the words dismiss the charges and offer a non-disciplinary consent agreement for that amount and for those hours. And yeah, they would not be, I mean, it would not be reportable. Because this would be a board action, even if you decided to be non-disciplinary, we are required to report it to audit. So if the charges are dismissed, then there's no case. That answers your question.
Yes, sir. Thank you.
All right, so at this point, unless anybody has anything else to offer, we'll consider the record closed. This board's going to go off the record to deliberate, and once they, if someone has a motion to make, we'll come back on the record and hear that motion. All right, so we're off the record.
I would like to do that for him if the others are in agreement.
Repeat it. I could barely hear it.
I would like to do that for him if y'all are in agreement.
Oh, what Becca, I believe, was saying, somebody before you, what you're in agreement with. That's what I was.
I asked if legally, if we have the option to, and the answer was yes. Rather than take an action in this formal hearing, we can make a motion to dismiss the charges and send him a non-disciplinary consent order for requiring him to do 2.5 hours of CE, extra 2.5 hours of CE. What was it, $125 for the missed hours and $375 investigative costs, and then that way it's not reportable to the National Practitioner Data Bank as an action.
Yeah, I agree too. I think that's good, Debbie. Yeah, it's a good idea.
I'm gonna credit coffee for the idea.
Black coffee is great.
Dr. Richmond, you've looked a couple times like you were about to speak.
No, I'm fine.
Who wants to make our motion?
I will.
All right.
Before we go back on the record, can I?
You don't have to worry about the charges or the allegations. That's all you have to say.
So the motion will be to dismiss the charges in this matter and impose a non-disciplinary consent for $100 per hour of dismissing the investigative costs of $375 and provide proof of the additional 2.5 hours. Is that correct?
And the fine and the payment. That'll get them, I mean, it's 2.5 months.
I'll second.
All right, well, I tell you what, let's go back on the record and get all that, and then we'll finish with this matter. All right, we are back on the record in the matter of Dr. Spencer Johnson, case number 2021-CE029. I believe the board has a motion.
Before we go into that, I just want to get, Dr. Johnson, you're agreeable to this?
Yes,
Thank you. Just wanted to-
thank you.
In the matter of Spencer Johnson, PD 12664, case number 2021-CP-029. I make a motion that we dismiss the charges for this notice of hearing and impose a non-disciplinary consent agreement where Mr. Johnson will pay $100 per hour for each hour that he was short, plus provide the board with 2 times the CE requirement and impose a $375 investigational cost, non-disciplinary fine, and that he provide both payment and proof of CE by the end of this calendar.
Second.
I believe Dr. Mack, motion by Dr. Jolly and a second from Dr. Mack. Any other discussion? All in favor?
Aye.
Any opposed? Motion carries.
Dr. Johnson, do you still live on that East 4555 Murray?
Yes,
And that's a good mailing address?
yes, sir.
Okay, that's where it'll be sent. Thank you. I'm sorry, Mr. Jones.
No, it's fine. I was just going to conclude by saying, we'll make sure you get a copy of that in writing. We'll come to you in mail. And then, but unless you have any other questions or comments, the hearing will be concluded, the record will be closed.
We'll get it sent to you in the next couple of weeks.
Hey, Dr. Johnson, how's the weather there in Utah? Is it snowing there?
It's snowing. It's snowing.
Well, I'm ready for that. I'm ready for it to get, some of it to get this way and the heat to break here in Arkansas.
No.
Thank you very much.
Have a good day.
You too.
We have, it appears we have Jennifer Settlemeyer. Dr. Settlemeyer, are you there? I see your name. If you turn your, unmute yourself and turn on your video, please.
I believe you're muted, Dr. Settlemeyer. Can't hear you.
Can you hear me now?
All right, hey, good morning, Dr. Sutherland.
Good morning, how are you?
Doing well, so I tell you what, we'll go ahead and get started with this. I'm the hearing officer today. I'm just kind of like, I just direct traffic, make sure everything flows
Sure,
right.
yeah.
Before we get started, I'll just I sort of go over the ground rules, how it's gonna flow today. If you have any
Okay.
questions. Okay, so this is an administrative hearing before the Arkansas State Board of Pharmacy. It is Thursday, October 14th. It's a little bit after 9:30 a.m. We're at 322 South Main Street, Suite 600, in Little Rock, Arkansas. This is in the matter of Dr. Jennifer Settlemeyer. It's case number 2021-CE045. So the board has set a hearing for today concerning the matter specified in the notice of hearing. My name is Jake Jones. I'm an attorney and I'll serve as the hearing officer in this matter. Dr. Settlemeyer, you're here. You aren't represented by counsel or anything like that.
No,
It's like you're at work today, and that's fine. You don't have to be. Could you go ahead and introduce yourself for the record?
sure. Yeah, my name's Jenny Settlemeyer. I don't remember for sure when I got licensed in Arkansas. It was a reciprocity whenever I first graduated. But I work in Tennessee, and I have secondary licenses in Arkansas, Mississippi, and Kentucky for Kroger.
Okay. Then did you receive a copy of the order and notice of hearing?
Yes, I did.
Okay, good. Councilman State, can you introduce yourself, please?
Luke Daniel, General Counsel, Arkansas State Board of Pharmacy.
Okay, so Dr. Settlemeyer, the board will base this decision today, solely on what it hears today. The board doesn't know anything about your case other than what's in the order and notice of hearing. So
Sure.
anything that you want to present today, which will probably just be your testimony. But if you have any documents or anything like that, make sure that you get them to the staff. So the board, that you want the board to consider. But that's just sort of a ground rule. The board's not going to consider anything that doesn't come into evidence. And as far as evidence goes, the strict rules of evidence don't apply. So if anything's relevant, it'll come in. We have a court reporter today that's recording, everything that's being said. So, make sure when you speak up clearly, distinctly, don't talk over anybody. Let's see. So these board procedures are subject to the Freedom of Information Act. So all of everything's open to the public. And it's kind of weird because the board will be deliberating and, we don't leave the room, you'll still be able to hear it, but you can't interject. And, if you hear the board say something, you can't interject. Once we've closed the record of the board's deliberating, you can't really interject and break in. But if you need to hear something you need to go, that you want to clarify or correct, and you want to go back on the record, we can do that. Just let me know. So those are just kind of the ground rules. But at this time, anyone who's going to be a witness in this, you raise your right hand and be sworn by the court reporter.
Is that me?
Yes.
Are you talking
Yes.
about besides me? Okay, sorry.
That's not for yourself.
Okay, I'm raising my right hand.
Okay, yes.
Do you solemnly swear or affirm the testimony you're about to say will be true, whole truth, and nothing but the truth?
Yes.
Okay. Are there any preliminary matters?
Just ask you to take judicial notice, Arkansas statutory law, pharmacy board rules and regulations, and remove the exhibits 1 through 5 at this time.
All right, we'll take notice of the statutes and regulations. And Dr. Settlemeyer, did you see the exhibits that the state sent? Did you get a copy of all those exhibits?
Yeah. So I received the email and then I emailed back with all of my credits that I had, and I was 4 hours short of the live CE. And I'm sorry.
Do you have a problem with the exhibits that the state had with the board considering those and looking at them? You're not objecting to those?
Oh, no, not at all.
Okay. And did y'all get a copy of what she sent in?
We did.
Okay, so all of that, we'll introduce all that into the record of the state's exhibits, the exhibits that you sent in, and all that will be on the record for the board's consideration. Ms. Daniel, you ready to proceed?
Ma'am.
Dr. Settlemeyer, are you ready to proceed?
Yeah.
Okay. All right, well, you can make an opening statement. And so if you want to make an opening statement, you can. You don't have to. An opening statement is just kind of a roadmap. It's like tell the board what you expect them to see by the end of this hearing, but you don't have to, the state's not gonna make an opening statement, you don't have to make one. You'll get a chance to testify, and you'll also get a chance to make a closing statement, and sort of tell the board how you'd like to see the case come out. But if you'd like to make an opening statement, just sort of the roadmap, what you expect the board's gonna see, you can.
I'll just wait until I'll just explain it once whenever it's my turn or whatever.
That's perfectly fine. All right, Mr. Daniel, you call your first witness.
State Health Deputy Director, Brendan McCready. Dr. McCready, this is the CE audit from 2000 in the 2018-19 years, correct?
Yes.
And I know we talked about this earlier, but just for the record in this matter, if you could just give a brief description of what that entails.
Once all the pharmacists have renewed their licenses, renewal actually closes. We receive documentation from CPE Monitor and from the renewal database showing how much CE they have reported. At that point, we go in and do an audit. When I do the audit, it appears that they are short either live or non-live or ACE hours, I will send a letter to the pharmacist stating what I show and asking them if they can provide their continuing education. And at that time, most of the time, the pharmacist will send that back in. If I don't hear from a pharmacist, I'll go ahead and double check the CE Monitor to see what hours they have. In Arkansas, sometimes there's some hours that the association might have that aren't ACP accredited, or in the past, and I've called them and asked them to send those, match all of those up, and give them an opportunity to send me whatever they have. Once I've received a response back from them, or if I don't receive a response, at a point, we will send what we consider a consent agreement that tells them how many hours we show them short, what the fine will be, and how many hours of CE they're gonna have to make up to bring this to a resolution. And probably 95 to 98% of the time, we get them all resolved. We do have some that don't resolve, and that results in hearing.
Okay, and she was, and you sent her, and I'm looking at section 2 in the packet here. Yeah, so she sent you an email, this started probably what, summer of 2020, when you started getting information?
Yes.
Okay. So she received, I guess she received the first letter, and she emailed you in January this year.
She did.
And sent what is attached as exhibit 5, which is her transcript that shows, and I apologize for it was cut off. It shows that she had 26 hours, is that correct?
That's correct.
And so she was 4 hours short. Correct?
That's correct.
Or is 4 hours short. And I guess we never heard back when you sent her the proposed consent agreement. Did you ever hear anything back after that?
Not that I'm aware of.
So we're here today because we never got a signed consent agreement, and this was it appears was the only contact was January this year.
Yes.
Okay. No further, thank you.
All right, Dr. Sotomayor, do you have any, you heard the questions that Mr. Daniel asked, do you have any questions for this witness?
No, I mean, that's accurate. I thought I had the 30 hours. I have the way the licenses renew, like Kentucky's in February, Arkansas is every 2 years, Tennessee's every 2 years, but it's in July, and Mississippi's every year in December. So I thought I had the hours between all of the licenses, but I was 4 hours short. And so I'm here today to know what I need to do above and beyond to make up for those 4 hours.
Okay, well, that's a little preview of your case. Board, do you have any questions of this witness? All right, seeing none, Mr. Daniel, do you have any more witnesses?
I did not.
All right, so the board's counsel has rested. All right, Dr. Sotomayor, now you can, you previously sworn, so you can testify as to the fact, just tell the board what happened.
Sure. It's basically what I just said. So I have multiple licenses in different states. I don't currently practice in the state of Arkansas, but I have it as basically a reserve license in case Kroger gets in a pickle and they need to send somebody somewhere. But I'm 4 hours short of the live CE. And so I do obviously need to do that in the timeline for the state of Arkansas, but I did not.
All right, Mr. Daniel, do you have any questions of Dr. Sotomayor?
No question.
Board, do you have any questions of Dr. Sotomayor?
Dr. Mack?
Just one. So you you checked in January and you sent it in. Is there any reason, once you got the consent order, you didn't just go ahead and take care of it?
I wasn't aware of basically anything. I asked in my email, like, what could I do? And then the next thing that I got was to present in this meeting today.
Oh.
So, I mean, if there's something that I should have done or can do, like that's, I mean, I'm here to do whatever you guys tell me.
Can I ask a question of Dr. McCready, or is that not proper?
We can go back and ask a question about Dr. McCready. Dr. McCready is still in the row, still sworn. So you can ask Dr. McCready now if you like.
Okay, Dr. McCready, did we send another thing after January?
We did, she actually said, if you look at exhibit 4, she sent me an email. It says, I apologize for the delay in response. I did not see the first email and I have moved the updated address below, so I did not receive the request in the mail. I filled out the form via email here and attached CE transcripts below. It appears I am 4 hours short of the 30-hour requirement for the last 2-year span. It appears it is the live hour requirements. I have 26 hours with 9 of them being live, and for the 2020 year so far, I already have 19 hours with 8 of them live. While I realize the time frame is not within the parameters, I hold multiple licenses in multiple states, and it appears the overlap of the time and credentials did not work accordingly. However, hopefully you can see that I do perform a more than adequate amount of CE in various titles. And the next page, there's the hours that she received in 2021 and 2018, 2019, and it shows a total of 26 hours in 2019. If you go over to the board's transcript from the CP monitor, which is exhibit 5, it shows 8 hours of live, 18 hours of non-live, for a total of 26 hours. Everybody that was on the list received a consent agreement mail to the address of record. And looks like it was left on May 27th, 2021 at 2:01 in Rossville, Tennessee, at her address of record.
Okay, thank you.
I have one follow-up for Dr. McCready while we're on here, if I may.
All right.
About how many hours of time is put in on this?
I would estimate about 5, just like the other years.
Thank you.
I believe my question was answered. There appeared to be a discrepancy in her email to you in that exhibit, and then how many hours of live CE she was missing. So that was my question, but I think you answered it.
All right. Any more questions of Dr. McCready? From the board, Mr. Daniel, Dr. Settlemeyer?
No question.
Okay, Dr. Settlemeyer, you can continue with your case. The board, if you have any questions for Dr. Settlemeyer, you can ask her now.
I don't have any questions.
Right, and you finished testifying. You told the board everything you wanted to hear.
Yeah. I mean, I was aware once I ran my CE credits that I was 4 hours short of the live.
Okay. All right, board, any questions, Dr. Settlemeyer? All right. Seeing none, Dr. Settlemeyer, do you have anything else to offer for the board before they close for deliberation?
No, I mean, just if you guys will tell me what I need to do to basically make up for the fact that I didn't have the 4 hours within the timeline for Arkansas, I mean, I'll do whatever I need to do.
Okay, and that can serve as your closing statement. Ms. Daniel, do you have a closing statement to make?
Just briefly, there doesn't appear to be like willful intent and, violate law. This is not a safety issue. This is a paperwork error on, it appears in her part, not getting off her seat. Staff has no issue with a motion to dismiss these charges if she will agree to a non-disciplinary consent agreement that will consist of completing 8 hours of live CE by the end of this year. That will be in addition to the 30 hours that she has already acquired, and pay $100 per hour that she is short. Again, for a non-disciplinary penalty, that would be $400. And since Dr. McCready testified of 5 hours of investigation work into this, we would ask that be recouped $75 an hour for a total of $375 investigative costs. So if she will agree, and if she will agree to the 8 hours of live CE, $400 plus $375 for a total of $775 by the end of the year, we would agree, or we would recommend, she will agree to that. We will recommend that these charges be dismissed. So, Dr. May I?
You can.
Ask her.
You can
Dr. Settlemeyer, if the board makes a ruling in this case, it will have to be reported to the national database. So if they were to offer to dismiss these charges against you, would you agree to pay that $775 and complete 8 hours of live CE by the end of this year?
Yeah, I mean, that's fair. I gotta do what I gotta do.
I just wanted to be sure when we had that she would agree to that. So that's what staff recommended.
It's extra 8 hours.
That's correct. It would be an extra 8 hours of live CE on top
Sure.
of what is already required for her license renewal at the end of this year. So she would have to be so I guess it would be a total that she already has 30, so it would be a total of 38 she would be required.
Correct. Yeah.
20 hours of live.
20 hours, that would be, yes. That's all I have to say.
All right, Dr. Settlemeyer, do you have any follow-up, anything you want to tell the board based on that, before they go into deliberation? You don't have to. You got anything you want to tell them before they close the
No.
deliberation?
I mean, it's fair. I was short.
Okay,
I don't believe so.
okay, the board thinks they have a motion, we don't need to go off record and deliberate, so we'll entertain motions from the board.
Does anyone want to go off record? Not seeing any. I would like to entertain a motion.
Okay, in the matter of Jennifer Settlemeyer, PD number 12876, case number 2021-CE045. We want to dismiss that case, and in return, we want to offer a consent order for her to get 4 hours of CE. And it's going to be charged for $100 per hour, for a total of $400. And she has to get 8 hours of live CE. And for investigative costs, it's going to be 5 hours at $75 per hour, for a total of $375. And for a total cost of $775.
Do you want to add both penalty hours of the year?
Yes. And these are all due by the end of the year, December 31st, 2021.
We have a motion from Dr. Newsom. Do I have a second?
Second.
A second from Dr. Jolly. Any further discussion? All in favor?
Aye.
Any opposed? The motion carries.
All right, so that's, decision is unanimous, and Dr. Settlemeyer, you'll get a copy of this in the mail. So,
Okay.
Find out everything that you're supposed to do. But unless there are any more questions from you or anything else to offer, we'll consider the record closed.
All right. Sounds good. You guys have a good rest of your day. Thank you.
And I'll get you a letter, I'll get you something, I'll get you this consent agreement in the mail in the next couple of weeks.
Okay, that sounds awesome. Thank you, guys.
Thank you.
Bye-bye.
Thank you for we are going to move to 10 o'clock. US compounding. Before we go on the record, first I would ask Dr. Mitchell to excuse due to her past employment with US compounding. She has agreed to do that. So we just ask you not to be involved in any discussions or in any voting if it gets to that. We have.
Before we get in, can I ask you just a quick?
Sure. Let's take
3-minute break.
Yeah, let's take about a 5-minute break. I believe have a request from a board member here. So let's take about a 5-minute break and then we'll get back on. No, no,
Luke, do you want us to turn on?
yes.
Luke, this is Debbie. Can I ask you a question?
I'm sorry.
Can I ask you a question?
Sure. Hey, hold on a second.
You know, I'm going to start listening, or I can start listening to this, but at about 11:45, I'll be on a plane, really at 12, but d- I don't know how long this is going to take. I didn't realize this one would start this late, so I didn't know what you wanted me to do. And I don't know how many people you have and all that, if you have enough.
You're
Okay,
muted.
yeah, if you would just hang tight, we've got a proposal that actually may resolve this case without having to have a hearing. So that's kind
Okay.
of, we've got Mr. Singleton and Miss G here. So just hang
Okay.
out at least for the proposal.
Oh yeah, I've got till noon. I didn't want to mess anything up.
Perfect, thank you.
Thanks.
Y'all get more high tech every time I get here.
Yeah, will you turn your mic off? The mic is now back on in the boardroom. If the board members will, those that are back, if you will turn on your video, so we'll know you're back.
Can you repeat that, Luke?
I was just saying, we're back on, or, the video and audio is back on in the boardroom. We were just asking members to turn the video back on, so we'll know when everybody's back. Ms. Harrison, we're gonna remain off the record for a few minutes with settlement agreement. Or proposed settlement agreement. Dr. Mack, are you back?
Yes.
Thank you. We have, and like I said before, asked Dr. Mitchell to accuse on this, and she has agreed to do so. What I asked Dr. Mitchell, he will serve as the chairman of this hearing, since Dr. Mitchell had accused of it. We are here on U.S. compounding today. This has been set for a while. We have Erica G. and Jeff Singleton from Wright Lynch and Jennings, a law firm here in Little Rock. They're U.S. compounding's local counsel. We have gone, board staff has met with Ms. G. and Mr. Singleton a few times over the past couple of months on this issue, on U.S. compounding. We've kind of gone back and forth about a way to possibly get this worked out. But we have come, the staff and council has come to what we would like to present today is a proposed consent agreement to resolve this case. So if we have, like I said, we're scheduled for here today. If the board, we're going to present this in just a few minutes. If the board accepts this case, accepts this consent agreement as a resolution, we would just go on the record and state that the charges, this case has been dismissed based on a consent agreement. If the board talks about this in a minute, and like I said, this is off the record, this proposed agreement is not being recorded, or it's not being transcribed, and will not be part of the official record in this case. So if the board talks after this is presented and does not want to accept this, we will go forward with the hearing right now. So we have Ms. G and Mr. Singleton, and we have your permission and your client's permission to make this proposal, even though there might be information come out that there might be admissions come out, that we have your permission to present this to the board on the basis that anything in this proposed consent agreement and in this settlement conference right now will not be used at the hearing.
Correct.
Okay. And that is what we have agreed to. Like I said, this is kind of a negotiation, kind of like mediation. So this is part of trying to get this resolved. So we're going to go through some facts in a minute and some admissions that U.S. compounding is making. So if that is not, if the board does not accept this consent agreement, statements that are made right now in this proposed agreement cannot be used against U.S. compounding if this goes to the hearing. So we have come to that agreement, and they have agreed to allow us to present this. So, and this all started back, Dr. Kevin Robinson, you see here, board inspector. This all started with an investigation that he was working into some seraphim issues with the way it was packaged. There was just unknowns. There was no ingredients. It was just an investigation that he started looking into. We then started getting into some issues where we received some complaints from former U.S. compounding staff. So Dr. Robinson, like I said, I looked into this along with Dr. McCready. There were issues with ratios, technician ratios. There was a lot, this mostly concerned with that side of U.S. compounding's operation. So if I'm looking at the consent agreement, I have not made this public and did not send it out, so I will walk through a couple of the things here, and then I'll let Ms. G and, Mr. Singleton add anything else that they want to. So on this, so like I said, this is a consent agreement, just like we would offer in former case, we're proposing this to the board. To the board, staff's recommendation to the board is to accept this consent agreement. We believe that it will resolve this matter and, efficiently and in a way that needs to be resolved along with appropriate penalties. At this time, U.S. compounding is closing. So regardless of what is resolved, regardless of how this is resolved today, U.S. compounding is not going to be in business. They have sold, their parent company has sold part of their book. They're not really company like their book of clients, and U.S. compounding is dissolved. So they do possess a wholesale permit, and they also possess a retail pharmacy permit, and are licensed as a 503B outsourcing facility with the FDA. So under the findings of fact on this proposed consent agreement, it does state that respondent who is U.S. compounding failed to ensure prescribing veterinarians licensed into the state which product is ordered shipped. So there are issues with unlicensed veterinarians prescribing products that U.S. compounding is filling. Respondent allowed for insurance of veterinary products directed to consumers without receipt of legal records or without receipt of a legal prescription. U.S. compounding failed to ensure proper pricing of product in which veterinarians collected payment for product or veterinarian was an intermediate in financial processing. U.S. compounding provided remuneration directly to a veterinarian in connection with prescriptions. Respondent provided veterinary prescription drug to animal's owner without the authorization of a licensed veterinarian. U.S. compounding filled veterinary prescriptions from emails received from U.S. compounding sales representative without a valid prescription. Respondent filled veterinary prescriptions from patients who did not have a valid practitioner-patient relationship. So the main, most of what I just described, like I said, has to do with them dispensing prescription medication without a valid prescription for vets. They had a huge veterinary business. They had sales reps that were literally emailing in saying, hey, I need this prescription, I need that prescription. It was going out a lot of times to the sales reps, so there was not a doctor or there was not a veterinarian. So like I said, Dr. Robinson got put in a lot of time and got deep in this investigation and uncovered all of these issues that were going on. So the conclusion here is the proposed conclusion of law. Respondent's operation as described above is contrary to applicable regulations that constitutes grounds for disciplinary action. So this is a disciplinary action consent agreement. And here's the order. Respondent, which is U.S. compounding, shall surrender licenses WD 03144 and AR 020503 effective October 31st, 2021. The reason that is, at the end of the month, instead of immediately, there's no product there. Like they're not still shipping, they're not still filling prescriptions. There's no issue there. They still do have some bulk product and other stuff there that they're having to return. They have a license to do that. They're trying to get it shipped back third party. There's no issue. Staff has no concern that there's any product whatsoever going out of U.S. compounding at this time. Like I said, the book of sales is gone. Everything else is gone. They have one or two staff members that are still there just to resolve the business. Resolve the business. So that's why that is the license to be surrendered at the end of the month. Number two on the order is respondent shall pay a civil penalty of $75,000 within 30 days of the date of this order. That is pretty much is what's been offered to resolve this. They pay a $75,000 penalty. Like I said, this is a disciplinary action, so it's not, it's something that will be reported. Respondent shall be ineligible for licensure as a pharmacy or wholesale distributor in Arkansas without further action. So if they ever want to come back to Arkansas, they have to come before the board at that time and resolve or give permission. 4, Respondent shall pay investigative costs of $75,000 to the board within 30 days of this order. After looking into how much time that Dr. Robinson put in, there was also Dr. McCready, Dr. Kirtley. There was a lot of staff members involved in this, so we calculated that up at about 1,000 hours of time, most of which was put in by Dr. Robinson. So at $75 an hour, that would be a total of $75,000. So that would be a total of $150,000 paid to the board, which within 30 days of this order. Both permits are surrendered on no later than October 31st of this year, and they will not be able to license again in Arkansas without gaining official authority to do so. So that is the proposal that we would like, or that we would, the staff and his contact council has agreed to present today. Staff believes this is a good resolution in this case. They will not be in business, are not in business, and this fine, we believe, with the investigative cost is enough to have the board prove a point that this is not, these actions and this will not be tolerated in Arkansas or by a pharmaceutical license. So that is our presentation. I will let Ms. G and Mrs. Singleton, if they have anything to add to that.
First of all, thank you everyone for hearing us this morning. We appreciate the efforts of the board to work with us. I'm going to keep this short unless you guys have any questions for us. I echo what Mr. Daniel said. This has taken some maneuvering. We've worked with the board, we've worked with our clients. We believe this accomplishes all of the design purposes that the board needs. It protects the citizens of the state from the current or future threats. It contains incredibly robust findings within the order that should deter any, serve as a warning to anyone else out there. It provides finality to all parties involved. So we certainly are here to answer any questions at this point that the board may have as it relates to the consent order itself. I can certainly outlay a bunch of other policy reasons this makes sense, but I will keep it short and I won't prolong this any longer than necessary at this point. Unless you guys have some questions, so we appreciate the opportunity to get here for you to address this.
And just to back up something he said, this consent agreement does have conditions in it. I mean, they are admitting that yes, we violated these laws, we did this stuff, it does have conditions. This is not one of those that just says, not admitting anything, but in lieu of blah, blah, blah. I read them out. There are conditions in here. They are admitting. So, like I said, I just wanted to get that out. But I would be glad to answer any questions. I know Ms. G and Mr. Singleton would be glad to answer any questions that board members have. That being said, staff along with them would ask that this proposal will be accepted and it can be signed today. We just ask this to be accepted and move over for the hearing. We believe this is a good outcome for both sides.
Okay, so board, if y'all want to, we can, y'all can take some time to review it, look it over if you want, and then, we can go on the record and just make a record of, whatever y'all want to do.
And I haven't made copies, but I would be glad to read. I didn't want, if this was not accepted, I did not want the order out there. So I have not sent this order out. I do have it here. Like I said, we'll be glad to read through any admissions or anything, or any part of the order or the facts that any board member would like.
Okay, did any board member want any details?
I had one question. So ineligible for licensure, I'm not familiar with it. Is that anyone that's involved in ownership? The company who doesn't contact?
The company, they are owned by a corporate entity that has other, like this is not, it's kind of a structured ownership.
I think to further answer Dr. Bradley's question though, if we had another corporation that looks similar to this from the ownership, we review that on every application. So if there are problems, that would still come before the board regardless.
Yeah, all the 503, especially a 503B application, those are all reviewed by Dr. McCready and Dr. Robinson. So yeah, it would be. Dr. Mack.
Just one quick question. I know you said this, Luke, but I wanted to make sure.
So this is disciplinary and they're not going to have a license in Arkansas? Can you just repeat that small part?
That is correct. Under the order, and I'll look and I'll just read you the actual where it says, there is the findings of fact, which are the admissions, and under the conclusions of law, it says respondent's operation as described above is contrary to applicable regulations and constitutes ground for disciplinary action. So yes, it is disciplinary action, and and as part of this order, they will surrender their licenses, both licenses, wholesale and pharmacy license, effective October 31st, 2021.
Thank you.
Did anyone else have any questions or discussion? So what does the board want to do? Go ahead and accept this proposal, or go ahead and proceed with the hearing?
We are on the record. All of this is on the record. The only thing we go on the record for is either have a hearing or the board vote to accept this.
So, are you,
I'm comfortable with, accepting. Staff's recommendation. So, I know they've done, I thought they've done.
so, what is the, which of the other board members that are in Zoom land?
The consent agreement's acceptable for me.
Thank you.
It is for me as well, this Debbie.
Thank you.
Same with me.
Thank you. Ms. Ford, Dr. Richmond,
I concur.
got a thumbs up and, okay. All right, looks like we're gonna, after our little poll, we're gonna go ahead and accept the proposal.
Okay, I would like for us to get on the record just briefly,
Yeah.
and if you'll just,
Yeah, I'll.
you'll just announce the case. we'll
Yeah,
go on the
I'll
record.
turn it over to you
Yeah,
and you present the consent agreement.
Dismiss the hearing in lieu of consent agreement.
So, yeah, I'll just tee it up and then turn it over to you, but y'all can put whatever you want on the record.
Thank you.
Okay, this is an administrative hearing for the Arkansas State Board of Pharmacy. It is Thursday, October 14th. Times are just a little after 10:20 a.m. We're at 322 South Main Street, Suite 600, Little Rock, Arkansas. This is in the matter of U.S. Compounding Incorporated. The case number is 2020-081. Mr. Daniel, I believe you and opposing counsel have talked and come to an agreement. I'll let you put that on the record, but the board make whatever decision they need to make on the record.
Thank you, Mr. Jones. And just for the record, I have asked, my name is General Counsel for State Board of Pharmacy, have asked Board President, Dr. Rebecca Mitchell, to recuse from this case due to her past employment with the respondent, U.S. Compounding. And Dr. Lenore Newsom, who is the chairperson of the board, I've asked her to chair today's hearing. Dr. Newsom, will you just do a quick roll call just to show who's present and that the board has quorum?
Yes, we have present, Dr. Brian Jolly, Dr. Lynn Krause, Ms. Carol Rader, Ms. Amy Ford, Dr. Rodney Richmond, Dr. Debbie Mack. And we have, Dr. John Kirtley as our, executive director.
Thank you, Dr. Newsom. So I show, just for the record, show all board members present. Like I said, with the recusal of Dr. Mitchell, which would make 7 members of office for. Ms. G, Mr. Singleton, will you introduce yourselves and who you represent, please?
Erica G. and Jeff Singleton of Rutland G. and Jennings here on behalf of U.S. Compound.
Thank you. And just for the record, Ms. G, board staff and yourself, Mr. Singleton, have this proposed consent agreement to present to the board for its acceptance today to resolve this matter in lieu of a hearing. Is that correct?
That's correct.
Thank you. Board members, we have this consent agreement, this matter of U.S. Compounding is set today for a hearing. We have what we believe is a fair resolution of this case. It benefits both sides and the matter will be resolved. So what we are offering in lieu of a hearing today As a consent agreement, there's a finding of facts in this. U.S. compounding does make admissions to violating Arkansas statutory law and rules and regulations concerning their compounding business, which was located in Conway, Arkansas. The licensure that the U.S. compounding board, the permits the U.S. compounding bill was a host or is a wholesale permit, a WD 03144, and a in-state Arkansas retail pharmacy license, they are 20503. They were and possibly still are registered with FDA as a 503B outsourcing facility. So in these finding of fact, like I said, they do make admissions of guilt. In this case, under the conclusions of law, it says respondent's operation as described above is contrary to applicable regulations and constitutes grounds for disciplinary action pursuant to Arkansas Code annotated 179247. The order states, in lieu of revocation, respondent shall surrender licenses WD 03144 and Arkansas 020503 effective October 31st, 2021. That later date is so that they can continue resolving their businesses. They have no product there that is being shipped out. Staff has no concerns that there's any product going out of U.S. compounding. They do still have some bulk product there that is they're being returned, so they still need to remain licensed to do that for first distribution. Like I said, staff has absolutely no concern that there's any product coming out, so that's why we have agreed to allow them that extra time. But their license will be surrendered on October, both licenses on October 31st of this year. 2, under the order, respondent shall pay a civil penalty of $75,000 within 30 days of the date of this order. Number 3, respondent, U.S. compounding shall be ineligible for licensure as a pharmacy or wholesale distributor in Arkansas without further action of this board. Number 4, respondent shall pay investigative costs of $75,000 to the board within 30 days of the date of this one. So that is the proposal that we have, the staff is making today, along with Ms. G and Mr. Singleton. Like I said, both sides agree that this is a beneficial way to resolve this and that it is good for both sides. Ms. G, Mr. Singleton, this is what I've just read is your understanding of the proposal today that is to be presented, or that was presented to the board.
That's correct.
And yourself, along with your client, U.S. compounding, agree to this.
Correct.
Thank you. Dr. Newsom, I will turn over to you and ask the board to accept this proposal in lieu of the hearing today. And if that's done, if the board votes to accept this proposed consent order, we would ask that the case be dismissed.
Do we need to go off record and deliberate, or does the board have a motion? Dr. Krause has something.
Yeah, I move that we accept our general counsel's proposal.
Okay, we have a motion, and do we get a second?
Second.
Got the proposal of our council, we got a second?
I think Dr. Richmond second.
Hey, Carter?
Dr. Richmond, was that a second from you?
It was.
All right, thank you, I can hear you clearly. Is there any further discussion? If not, all those in favor of the motion, signify by saying aye.
Aye.
Any nays? And I'd like to also put on the record that Dr. Mitchell is recused. Thank you all.
We all want to sign this one. We can go on record. I'm just having to sign this, and I'm going to ask you to sign it, and it'll be official.
Hey, board staff, thank you for all your hard work on this case.
Yes, sir. We have 3 more of CE, but I'm thinking in here, so it should be short.
Thank you very much.
Thank you all. See, I can say about that.
Thank you.
Yeah, just, we have three more, CE hearings that, I don't believe any of the respondents are here, so they should be short. So if you'll give us just a few minutes to get this wrapped up, maybe take a 5-minute break. See if we can start back with those.
It's gonna go down.
All right, we are back on, recording.
All right, we will continue with our hearing. The next is before the Arkansas State Board of Pharmacy. It's in the matter of Brenda Carter. It's case number 2021-CE009. And so it appears that Ms. Carter is not here. Has the hall been sounded from Ms. Carter?
It has, I have checked out front with, office staff, she is not present, and nobody's heard from her.
All right, so we will go ahead and Mr. Daniel, you can proceed with the case. And just, make sure you're, proof of service for notice of hearing, award, and everything.
Thank
You
you.
can go ahead and present your case, and anybody that's going to testify will be sworn, you can be sworn at this time.
Besides, that the testimony you're about to be sworn.
And just for the record, Dr. Mitchell, we do have all 8 board members present, 5 on Zoom, and 3 present in the board. Is that correct?
Yes, sir, it is.
Thank you. This is Brenda Carter, PDO 7524, case 21-CE0009. Sorry, 00. At this point, Mr. Jones, I would ask you to take additional notice of Arkansas statutory law and pharmacy board rules and regulations, and move to enter exhibits 1 through 6 at this time.
All right, notice of the statutes and regulations will be taken, and the evidence, the exhibits will be admitted into evidence for board's consideration.
Thank you. Dr. McCready, looking at, will you just state your name and occupation for the record?
Brenda McCready, Assistant Director, Arkansas State Board of Pharmacy.
Thank you. Looking at exhibit 1, which is the order notice hearing for today, and I'm looking over it. I guess it'll be the second page. Looks like the 4th paragraph down there. Does it have today's date for hearing, October 14th, 2021 at 9 a.m.?
Yes, it does.
And has she been present today, either via Zoom or in person?
She is not present.
Have you had any contact with her regarding this matter?
I sent her an email again last week to remind her, but I have had no response from her whatsoever.
And I'm looking over at exhibit 2. This is a proof of service, and it shows that it was actually mailed to the address on record she has on board.
That's correct.
And I'm looking at exhibit 3. What is that address?
All States Court, Little Rock, Arkansas, 17223.
And on the order notice of hearing, that's the address that it was mailed to.
That's correct.
It was actually sent to, it was also sent to the email address that is on record with the board.
Yes, it was.
And I'm looking at exhibit 4, which is, in this date, the date on this order is May 19th, is that correct?
Yes, it is.
And I'm looking at exhibit 4, which is an email from her from also May 19th, is that correct?
Yes, it is.
And so it states, she kind of goes into a rant in her email, but on that date, it shows, this email shows that she did in fact receive this order, correct?
Yes, it does.
And actually kind of directs the board with lawyers.
Yes.
Correct. Back to the reason we're here today, which is the CE issues. And I know this has been said before, but just for the record in this matter, we just give a brief description of what the CE audit is and kind of how you go through that investigation.
Arkansas law allows for a continuing education audit after the rules are closed. The Board of Pharmacy accesses CPE monitor and the renewal database to look at the CPE that's been reported by the pharmacists that are licensed in the state. I get all of that information in, we do a comparison of what's reported versus what has been actually shows up in the CPE monitor. If there's a difference, we'll send a letter to the pharmacist asking for proof of any additional hours that will bring them up to their required 30 hours every 2 years. And 12 of those have to be live, 12 have to be ACPE. Those 12 live ACPE can be the same hours, but they do have to have a total of 30 hours every 2 years. We'll send that letter requesting documents. The pharmacist will normally respond with a letter stating I have these documents that are not ACP hours, but they are including educational hours. The board will determine whether they're approvable, we'll take those hours. And once we resolve those issues, we look at any that are remaining. We'll send them an additional letter stating you haven't received anything. And at that point, we will put together a consent agreement that outlines what the requirements to rectify the situation are. And that's normally $100 per hour fine that they're short, as well as making up double the number of hours, whether it be live hours or non, depending on which they're missing. We'll send that consent agreement out. We normally give them 30 days to sign the consent agreement, and then an extra several months to get us all the documentations to pay the fine, et cetera. When we don't hear from them for that consent agreement, then we will schedule them. We'll actually try to contact them. If we don't hear from them and can't reach them, then we will schedule them for support.
So when this audit first started, she would have received a letter asking her to respond to the audit.
Yes, she will.
Did you get a response from that?
I did not.
So then you would have secondly sent a certified letter asking her to respond to the audit, correct?
Yes,
Did you get a response to that?
I did not.
Next, you would have sent a letter with a proposed consent agreement to resolve this matter. Did you get a response to that?
I did not.
So the first response the board received was when it mailed the order notice of hearing, which has a date of May 19th on the letter and is signed, which is signed the 20th day of May. But it was actually sent to her on May 19th, correct?
That's correct.
And so the only response we received was Exhibit 4, that email from her on the same day she received the order notice of hearing, correct?
Yes.
The board also mailed her a copy of today's exhibits. And you sent an email to her reminding her of today's hearing. Did you ever get a response from anyone of those?
I did not.
And back on, and looking over at Exhibit 5, this is her CPE monitor, is that correct?
That's correct.
So how many hours did she ended up being short?
She had a total of 18.75 live hours, 1.75 home study hours for a total of 20.5. So she was short 9.5 hours.
And that's a non-live.
That's not right.
So I have like,
I've got a question. Is this, pharmacist in practice?
I believe it's so, but I can never
let's
say.
see,
I had the same question because on Exhibit 6, somewhere it says non-practicing, I didn't know what that
Yes, it did. But that was kind of a sharp statement, which is saying it. Yeah, okay. I'm being kind of.
We do not show a place of employment report in our GL licensing database.
see if it shows the last. Nope. The only thing, the last thing we showed is the receipt. And that was back 2008.
And she was a pharmacist in charge up to 2014. And so,
I know previously when we've had these issues where, it's one thing when if they appear and say, yeah, I didn't get it, sorry, but for somebody to have, just not even attempt to resolve this matter. And I know previously when we've had these in previous years and it's come to this, we have asked the board to impose the fine penalty for, $100 per hour. Also the CE penalty for double the rate. Again, we're going to ask for investigative calls this year. Dr. McCready, what would be the investigative calls? Was it 5 hours?
yes,
So that would be $375. We've also, in the previous years, when people have not responded and not appeared, and we've had no, outside, the board has also made a condition of them paying that fine, paying the investigative costs, and completing that CE for the license to be suspended. So this is up for renewal, her license will be up for renewal on December 31st. So we would ask that this matter be taken care of by December 15th, or we would ask that our license be suspended by that date. I mean, you could make, I mean, this order, that it would be suspended on that date if the board has not received the items that are payment and the agency proof. So that's what, I guess this would be like a closing statement, that's what I would ask.
Is the timing of that so that it doesn't just expire?
Yes,
Okay.
because I mean, if you could just let it expire and not have to pay any, I mean, if you just let it expire, then we would have no, I mean, we would, you know, of course, I would seek the money, but if it's, I mean, if it expired, so I think with the,
Our renewals open, I'm sorry, our renewals open in towards the end of October, first of November. So she could renew before that.
even if she did, it was, I mean, it was, if they voted to suspend it, even if she renewed before that, it was suspend on December 15th.
And I believe she may be working with the VA government, possibly.
So that's why we would think, we would like, I mean, if she doesn't, if she still feels that she doesn't want to accept this, there needs to be some type of action. So if she doesn't pay, doesn't do the CE, we would ask for her license to be suspended on December 15th, and that is a little over 2 months and a day. She would have to get this stuff, but yes, to answer your question, that is so it would not expire.
Dr. Kraus, or you see something?
I did, well, was it Dr. Kraus, you have a question?
I just wanted Luke to just go over the points on that. I was trying to write them down and I kind of lost what he was saying, but I think basically what he was saying, if I heard him right, was what we've been doing with the $100 per hour miss, double the CE requirements need to be done in addition to the 30 hours. And if she fails to do that by the end of this year, then we suspend her license.
If we're, I would guess, except for, we would give her till December the 15th, which is 2 months and a day, and that way, her license would expire on December 31st if she did not renew it. So we're asking it to be December 15th, so that way the suspension can take effect before her license would expire if she did not renew it.
Thank you.
And that was my close, Mr. Jones. So if they have questions, I'll let answer. If not, I would ask go off the board, I mean, off the record board. Yes, this is recorded.
Okay, board, do you have any more questions for council or Dr. McCray? Do you have all the information that you need to make a decision to deliberate, or do you need more? Dr. Krause?
Are we off the record deliberating?
No, not yet. We're not gonna go off the record until y'all think you have all the information. I guess I'm asking now, do you have all the information that you need to go off the record and deliberate? Or do you want more information from council or Dr. McCray?
No, thank you.
Okay. All right, seeing none, we'll consider the record closed for the time being, and the board, do y'all feel like you need to go into deliberations, or you think you can come up with a motion without going off the record and deliberating too much?
Dr. Kraus, do you have a motion?
Yeah, I'll make a motion that we accept our general counsel's proposition on this.
So for the record, that motion was for was it an $850 or $950 fine?
It would be a $950 fine, which would equal an hour. I mean, would equal 100 hours for every hour that you short or see. Investigative costs of $375. That would also, and then double makeup on the CE, so that would be 19 hours of CE, in addition to the 30 that is required for this renewal period. And we would ask that this fine and investigative costs and proof of the CE be provided to the board no later than December 15th. And if it is not provided on December 15th, this order will suspend the license on that date.
I have a motion from Dr. Kraus, outlined very clearly by our counsel. Do I have a second?
I'll second.
I have a second from Dr. Newsom. Any further discussion? All in favor?
Aye.
Aye.
All opposed? The motion carries.
All right, let the record reflect that the decision is unanimous, and then, board staff will reduce that to writing and attempt to serve on respondent. All right, record in this case is closed.
Thank you, Mr. Jones. If we may go on to, last name is GUYA. What is it?
I'm just gonna call it Gaia.
Sounds good.
All right.
If we can go on to that.
Before we open the record, I have a question. I know it would not have helped us in the last case, but it sounds like we have had a couple of these where they're saying they like couldn't get or didn't get the order and maybe the consent order or some kind of communication because their address changed. And I realize it's their responsibility to change the board, but is it possible for us to also send that communication to wherever we have that they're currently employed, if we have that, or is that not allowed?
We can do that, and we've also sent it, if we don't get a response, I can personally also copy it on our email. We hopefully
I have, just for the record, I have, you know, the gentleman that was here earlier today, I went out to the NABP website, found out where he was working, got to contact him at work. I mean, it's not like we just send it and don't try to contact him. We go above and beyond trying to make sure they did this so that it doesn't come to us.
Legally,
We send emails, we look for the place of employment.
legally, we have to send it to their address of record, we send it certified. I mean, we spend a tremendous amount of money on postage, but we try to follow email, phone calls, contact lawyers. It's a lot about.
5 is probably
Generous,
Generous.
conservative.
Yeah.
Okay, thank you.
All right. So this is an administrative hearing for Arkansas State Board of Pharmacy. It is Thursday, October 14th, at about 11 a.m. for 322 South Main Street, in 600 Little Rock, Arkansas. This is in the matter of Mr. Gaia. Case number is 2021-CE022. So it doesn't appear that the respondent is here. Mr. Daniel, have y'all signed the hall and, you know, gone through the floor for the respondent?
We have, and we actually have, we received an email from him, I guess, the other day. Anyway, let me just back up just a little bit before we get started. Just want to get some record. This is another CE. You know, numerous notices have been sent, numerous notices. We received his, he was short, or is short, 12 and a half hours. On October the 8th, so just a few days ago, we received a check for $1,250 from him and approved his CE. So after a year and a half of trying to get this resolved, he did send that in on October the 8th. We told him that the staff was not going to accept it at that time. We asked the board today if they would accept it. And I believe Dr. McCready had an email from him just a couple of days ago saying he had to work or something and would not be available today. So, like I said, we can go through. So no, he's not going to be here today to answer your yes or no question in a very long sentence. But so that's just kind of want to get that on the record of why he's not here today, and we can talk about what the board wants to accept in a minute.
Okay. Well, you put that on the record. I'll make an attempt to contact him. I've had some contact with him, so you can at this point, and you know he's not here today, but so you can go ahead and present the case to the board.
Yes, I do. Ready to start?
Yes.
I would ask Dr. McCready to be sworn.
I do.
Dr. McCready, this is, I'm sorry before we start, but asked to take the judicial notice of the Arkansas statutory law and pharmacy board rules and regulations. It will move to enter exhibits 1 through 4 at this time.
All right, notice the statutes and regulations will be taken, and the exhibits will be introduced into evidence for consideration by the board.
Dr. McCready, this is a CE audit again, is that correct?
That's correct.
Yes, and like I said, I know you've gone through this several times today, but just very briefly for the record in this case, can you describe the CE audit process and, kind of how you work through that?
Once the renewal period is closed, we receive documentation from CPE Monitor as well as our licensing database that indicates how many hours a pharmacist has reported on renewal and how many hours they have reported into the CPE Monitor. We'll take those, sort of verify them. If they're short hours, then we will actually send a letter to the pharmacist asking them to provide the additional documentation showing that they've met their 12 hours of life, their 12 hours basically, for a total of 30 hours per biennium. And the 12 hours live and the 12 hours ACP may actually be the same hours, but they still have a total of 30 hours each biennium. We will send them a letter saying that we show them short, whatever number of hours they're short. They will, in most cases, respond and send me certificates, et cetera, showing where they went, they attended some other CPE education course, whether it's not ACPE accredited, that type of thing, so that we can see if they're approvable and count those hours. If we don't hear from them, we give them another opportunity to send those in. And at that point, after the second time we contact them, we will send them what's known as a consent agreement, which will outline the number of hours they're short and what they have to do to rectify the violation. At that point, probably 95 to 98% of the pharmacists will respond. We'll get those, they'll make the payments, send to their CPE, and it's resolved. We do have some every 2 years that for some reason there's no resolution, and we schedule a board hearing at that time.
And Mr. Gaia has actually had contact with the board a couple of times while this is going on, is that correct?
That is correct.
Okay, so this is not one where he's just totally ignored.
No,
And he was told by staff that he would just either have to consent to what was in the consent agreement or come to the hearing, correct?
that's correct.
So we never received that, so he was set for today, correct?
That's correct.
And on October the 8th, we received a check from him for $1,250 along with a copy of the order notice of hearing. Is that correct?
Yes, sir.
And so, he was short 12 and a half hours, so the check would correspond with the correct amount. Is that correct?
That's correct.
And we also received a copy, or he also sent in a copy of the CPE monitor activity transcript, which shows that during it shows during 2021 that he reported, he has recorded 82 hours of CPE hours. Is that correct?
He earned hours from 1/1/2018 through through October 6th of 2021 for 82.25 hours.
Okay, so he has enough makeup hours plus enough hours to cover what is owed this year.
Yes, he does.
But we have never received a signed consent agreement, as well as in last week with a copy of the order, correct?
Correct.
Thank you. Well, and he's not here, so he's going to say that we would ask that the board accept the fine payment, the board accept the CP hours, and allow him to sign a consent agreement for the additional $375 of cost. And
Do we know where he works?
let's just see this. And just for the record, Dr. Brady, look at the hours, they are live in the town. Nowhere listed. And like I said, if he's not working in a facility that's licensed in Arkansas, I think we have to list.
Unless he's a pick. He's a pick on a state facility, he would have to list that, but he's not picking. And he may have been a pick at one point, and he's no longer a pick of the mental license.
All right. Board, got questions?
Dr. Kraus?
You can ask either of, Dr. McCray or your counsel before y'all deliberate.
Yeah, so, Mr. Daniel, can you tell us if he doesn't sign the consent order, what recourse we have? Is there a suspension in line, or what do you think?
Yeah, we would just ask that we can give him 60 days to provide, or say till December 15th, to provide the extra $375 along with the signed consent agreement. If it's not done by that day, then his license will be suspended. It's kind of like previously, but like I said, the checks here, this transcript of his CE is here. We just did not want, since Dr. McCray put in so much time, this was last thing we already said. So we told him to just we still have to come for the board. But we would agree to accept his check and that transcript and an additional $375 of that consent agreement by December 15th.
His email does state that he will not be able to attend the meeting, but just let him know what the decision is, and he'll make sure he takes it into account.
Thank you. I'm sorry, I may not have heard it all.
No, you're fine. I know sometimes if we're looking away from the mic, I know sometimes it's hard to pick it up.
Do any members of the board wish to go off the record for deliberation?
Have you heard enough to make a decision? All right, well, at this time then we will, unless anybody else has any more questions, or there's anything else to add? Dr. McCray and Mr. Daniel will confirm. Unless anybody has anything else if they have any questions to ask or anything they want to add, I think the board can kind of discuss and come up with a motion. Okay, the board will turn it over to you.
I would like to entertain a motion.
Okay, in the matter of, K. Gaia, PD number 11776, case number 2021 CE 022. I'd like to make a motion that we accept what our council has stated. We're going to accept the payment that Mr. Gaia will send in and the CE and charge the $375 administrative fee. And
Sign consent agreement.
and everything be paid by December 15th, 2021.
And the consent agreement be signed and returned to the board by December 15th, or his license will be suspended on that day.
Correct. Thank you.
Okay, I have a motion from Dr. Mason. Do I have a second?
Second.
Second from Dr. Jolly. Dr. Kraus, did you have a question?
I was just checking.
Okay, any further discussion? All in favor of this motion? Any opposed? Let the record show that Dr. Debbie Mack was absent for this vote. The motion carries.
And just for the record, that was still a constant quorum with 6 members.
Yes, it does.
All right, well, the decision is unanimous and staff will reduce this to writing and serve it on the respondent. All right, the record in this case is closed. All right, y'all want to take a break before we move into the last case, or y'all want to just drive on and do it?
This is the last one. It shouldn't be any longer than the other ones. And probably by the time we get through this, we'll probably break for lunch.
All right, this is an administrative hearing before the Arkansas State Board of Pharmacy. It's Thursday, October 14th, a little after 11 a.m. We're 322 South Main Street, 600 Little Rock, Arkansas. This case before the board is in the matter of John Cornwell, case number 2021-CP012. It doesn't appear that the respondent is present on the Zoom call. Respondent's not here present physically. Have y'all sounded the hall and checked the room, see if you see, I mean, check the building here and see if he's here?
We have, and, but he's not present. He is not able to attend, but we'll get into that.
Okay, all right, so, yeah, well, at this point, then I'll let you go, in preliminary matters, I'll turn to you, present your case.
Thank you. We would ask you to take judicial notice of Arkansas statutory law and pharmacy board rules and regulations and ask you to enter exhibits 1 through 4 at this time.
All right, notice of the statutes and regulations will be taken, and the exhibits will be introduced for the board's consideration.
Thank you. And Ms. Harrison, would you please swear Dr. McCray in? Thank you. Dr. McCray, this is another CE audit, is that correct?
Yes, yes.
And I know this is about the 5th time today, but just for the record in this case, will you just give a brief explanation of the CE audit and what that entails?
The continuing education audit is conducted by Arkansas law. We wait until the renewal period is closed, and at that time, we receive documents from the CP monitor as well as what pharmacists have indicated on their renewals as to the type and the number of hours they have obtained during the biennium. At that point, we match the hours to determine that they've met the CE requirements of 12 live, 12 ACPE, and a total of 30 hours during the biennium. If those hours are not met, we will send a letter to the pharmacist asking if they have any additional hours that they need to report so that we can determine whether they have met the requirements or not. We send them a letter. If I don't hear from them once I process those, I'll send another letter out, and third opportunity, we'll send a consent agreement that indicates the number of hours they're short and what it's going to take to rectify the violation. At that point, probably 95 to 98% of the pharmacists respond and we get it resolved. There are a few each biennium that do not respond, and it does result in this board.
Thank you, Dr. McCray. And just, Dr. Mitchell, just a quick housekeeping. All board members are present except for Dr. David Max. We still have 7 members of council support. Is that correct?
Yes, sir.
Thank you. Dr. McCray, so, and this is from John Cornwell's. He does show, looking at his notice in order hearing, he shows to be 5.25 hours non-live short. Is that correct? For that biennium?
That's correct.
And you have spoken to him recently.
I have.
Okay, will you tell the board about that conversation?
I spoke with Dr. Cornwell on the telephone. He actually has been ill over the last several years and has been unable to actually get CE. He lives in a very remote area that does not have any internet access, and he's been home pretty much sick, bedridden, that type of thing, and has not been able to complete the hours. He's not worked in the state since 2018. And when I spoke with him, he asked that the board consider.
So he pretty much told you that he's not, he doesn't, I mean.
He does not attend class.
And does not leave his house, really. He's to the point of being, it's like I said, we just found this out, what, a few days ago? Yeah, I mean, it was this week. So I guess under the circumstances of all that being said, yes, he is. I mean, and he has attempted to get, I mean, it's gotten all but, like I said, 5.25 hours of non-live, based on his medical condition and the fact that it seems to be restricting him from even finishing his CE, who has his case dismissed.
He did actually give me permission to tell the board that he would not renew his license this year because he's not.
Dr. Kraus has a question.
Can I make a motion?
Yes, sir.
Can I make a motion that we dismiss this case?
I have a motion from Dr. Kraus. Do I have a second?
I'll second it.
Second from Dr. Newsom. Any further discussion? All in favor?
Aye.
Aye.
Any opposed? The motion carries.
We will get notice to him of this, and that is everything that we have set hearing wise. Ms. Harrington, always glad to have you with us. Thank you for being here today. Mrs. Jones, again, always a pleasure to have you with us. And will you mute real quick so we can. Board.
Can't hear you, Luke.
Yeah, all the sound went away.
Oh, we're back.
We're back, sorry about that. I will turn it back over. I was just telling Ms. Harrington and Mr. Jones, that's all we have hearing wise scheduled today. And it's good to have him with us as always. So we have, and I know there are some discussion items that I know Dr. Newsom wanted to talk about, and we have to set dates for June, so I don't know, and then so we can, I don't know, something quick we can do before lunch.
I'll check.
I don't think so.
Have y'all, and I know we talked yesterday, let me pull up my calendar. I know we talked yesterday about possible dates, and I believe the dates we're looking at June.
First Tuesday of the year.
And it's, it's kind of, I mean, it's usually the second week, or which would be the second Tuesday, Wednesday, but I know, which would be 14th, 15th, and I heard from board members, they have conflicts that week, so we were looking at maybe the 7th, 8th, and 9th. Setting it for 3 days, hopefully we won't need that third day, but it's there in case we do. And Dr. Kraus, I know you were gone yesterday afternoon, is that the 7th and 8th, does that pose a conflict with you?
No, sir, that's fine.
Okay, do those 3 dates pose a conflict with anybody else that they know of right now?
Can you
Yeah,
just,
I would ask.
I'm having a little bit of a hard time hearing. Can you just repeat those dates again, please?
I'm sorry, Dr. Richmond, yes, I was saying June 17th and 9th. It's usually scheduled to starting with the second Tuesday, but that 14th and 15th, 2 board members already have a conflict with that week. So we were looking at the 7th, 8th, and 9th. The 9th is needed, but go ahead and schedule it for those 3 days. And so if that's not an issue with anybody, I would ask Dr. Mitchell, we just have a motion to set the June board meeting on those 3 dates.
Do I have a motion?
So moved.
Second.
I have a motion from Dr. Newsom and a second from Dr. Jolly to set the board hearing dates for June 2022 of the 7th through the 9th of June. All in favor?
Aye.
Opposed? Motion carries.
And just for your knowledge, and I'll send out an email with all the dates when I send out one for June, but the board meeting in February is scheduled for the 8th and 9th, just if you don't have that on your calendars. And November informal is set on 8th and 9th, which is Monday and Tuesday. So we'll need at least, we like to have at least 4 members, so there's 4 or 5 of you that can look at those dates and see if you're available. And that's all I have personally, so I'll turn it over to, go back to Dr. Mitchell and Dr. Kirtley, if there's anything else that we can get in.
I think it's interesting, if you haven't heard, I believe that February 8th, maybe the first night that Hamilton is playing here for a while. So you have to probably get on tickets pretty quick.
Dr. Newsom, do you have discussion items?
Yes, I want to talk about the part-time, in pharmacies.
So I might say, not just necessarily specific to that company, but it is a discussion. I know Dr. Kraus also had his hand in it, but for years, we have had some dispensing physicians that are in specifically oncology, hematology oncology or oncology service. Some of those pharmacies or some of those organizations started with pharmacy permits right off the bat. We've got a couple that we've inspected for years where they're compounding suites, and then that also gives them the ability to dispense oral oncology products. Some of those locations are open 40 hours a week. What we are seeing with some of the, I would think, decrease in access to oncology services throughout the state, especially our smaller hospitals, we have some branches out there. In this instance, we are working with, a company that is interested in transitioning over to pharmacy permits, but there's some smaller communities, I mean, El Dorado being one of them, that it isn't feasible for them to be open full-time at the beginning. So the request is they have some that would be open full-time and they are transitioning over to permits and are interested in practice the other facilities, but they would need a waiver to be open less than 40 hours a week to serve those patients when they're only open like a couple days. So I did not think that would necessarily be a problem for those facilities. The specific medications they are dealing with are limited use, and they are also access to them is very limited. Most pharmacies would not even have access. Hospitals may, but they can't dispense them, they can only administer. So the request of staff is that the board would, basically commit that yes, we're willing to work with some of those limited use permits for limited hours in smaller communities, so that we can reassure them if they start spending money on this process that it's going to be a good thing.
I mean, I like the idea of some of these entities having a licensed pharmacy, because that means that there is a pharmacist involved. And I think that that's a positive all the way around. I guess my question is more logistically, like, are we wanting to authorize?
Excuse me.
Are we wanting to authorize the board staff to go ahead and approve that waiver? Does it have to come in front of the board every time? How does that work?
I think that's up to you guys. If the discussion we've had is there would be a phase-in process. But I think the biggest thing is that they're going to try to transition from physician dispensing to pharmacy. They need to know that you're going to work with them. We have informals where if it's a specific application, we can get it in front of them and do a final approval on it. But this is, I think, all going to happen like January to June.
Is there such a significant number of these expected that it's gonna affect our inspectors' workload?
No,
Okay.
I think it's just a handful of.
yeah, I think it's like half a dozen.
Do we need a motion or just?
I think
if you guys tell us you're gonna work with them, I mean, it's on a public record, that helps me in the discussion.
yeah, I mean, you got John, you've got Dr. McRae, you've got Kevin Robertson, they're all, I mean, especially, in this thing, they've all been to train, especially Dr. Robertson, on this issue, so I think staff is very adequate in assessing what, is needed and, issues and all that, so.
And we'll see the specifics of their applications once they're at the top. Because some of them are probably going to be, well, this one may be Monday, Tuesday, this one may be Thursday, Friday. It'll be, up to specified days. And we've given a waiver for less than 40 hours a week in the past, because it still fits in a retail permit, even though it's a very unique type of practice.
That's what I was about to ask.
That's the issue is, it doesn't fit under hospital, it doesn't fit as a surgery or anything else, because it is an on-site sterile preparation as well as oral products.
Yeah, and I don't think staff has any issue with them, with the waiver or any other,
That's the biggest question.
I think the other thing, correct me if I'm wrong, they're scheduling these procedures. I mean, these aren't,
Yes.
they're not providing emergency services.
Yeah.
These are all scheduled infusions.
Yeah,
Patients know ahead of time, when they're coming in.
How does it work with if there's physician ownership?
We do not have a rule against physician ownership in pharmacy. What we do have a rule about is that the freedom of choice is for the patient to be able to choose. So, I mean, these patients can choose a different entity to dispense these medications for them, but the medications we're seeing aren't available otherwise locally. They would have to get it from somewhere else. I mean, Dr. Crowley probably knows that better than I do.
Yeah, I think freedom of choice really comes in this setting when you're traveling 2 miles from home and you express to the facility that you would like them to try to find a place for you to receive treatment closer to home. And facilities work with patients on that, so.
Yeah, I don't think there, I mean, like I said, a small amount of these that exist, I don't know if it's gonna be a huge freedom of choice issue.
What about the whole, a hospital can't own?
These aren't hospitals.
There's no, they're not hospital owned. They're not.
Even if they were.
So it would still exclude any physician that has ties to any hospital. So we're excluding any physician group that has ties to a hospital system. It would still exclude all of those individuals. So we're saying that it's okay for this group, but not for this other group.
Yeah, these are not, these places, all the places that we talk to are for-profit. That connection to a hospital only applies to nonprofit status. So I don't know that we would have that issue with Spartai and all these places are for-profit entities. So even if they were connected to a hospital, I don't believe there would be an issue in getting a permit based on their for-profit status.
Any application like this is for, we have to actually review the overall ownership, because even if it is a for-profit arm, if it has a link to a not-for-profit hospital permit, it will be excluded. So the ones we have currently are completely separate from even any hospital at all.
I saw Dr. Kraus waving his hand a minute ago. Do you have a question or comment to add?
No, it was about something different, but in thinking about this, I think that, board staff handling it allows us to pivot and negotiate. It provides some continuity. I don't see a problem with that. I have faith in them that if anything weird comes up, they're going to bring it before us. So, I think this is I think it's a good thing.
It's connected to a hospital, it's a hospital.
If it's connected to a not-for-profit hospital, it would not be eligible for a retail permit.
Right, it would be a hospital permit.
But for the ability to both serve patients in a clinic setting and send drugs home, it would have to be a retail permit.
Most of these are complete infusions in-house.
Well, it's infusion in-house, and there's a lot of oral oncolytics that go in as adjunct therapy. I mean, there's more. I mean, the number of oral oncology products that have come out in the last decade is impressive. That's all I have on that.
Thank you.
Seems like Dr. Kraus had something.
He's shaking his head.
Just thinking.
So I know our staff also want to broach the subject with the board members that we are getting complaints in, sometimes from patients, sometimes from other pharmacies, that there are pharmacies that are closing due to inadequate staff. And it's something that we have always understood, that sometimes you might have to close the pharmacy for a day. Sometimes there's a funeral, sometimes there's a wedding, somebody has a car wreck on the way to work, and the pharmacy may not be open for a day. We are seeing more instances where pharmacies are repeatedly having to close, and sometimes they may still be open 40 hours a week, but it's not advertised hours. Sometimes it may dip below the 40 hours a week. We've asked a couple of companies that if they have pharmacies that are closed due to either illness or inadequate staffing or anything like that, we want to know each day when it happens. It is not a great situation for us when we get people calling us from other pharmacies saying, what are y'all doing about such and such store that's been closed for 3 days? And we're like, we had no idea. So we're working on that side of it. Dr. Brady's been taking point on that. But you guys need to know that. I mean, our staff has even had some concerns and even advised people at times where you may just need to cut your hours back to 40. You may need to tell people if you are so busy you can't get to prescriptions for days at a time, even when you are open, then maybe you need to start turning away business. Maybe you should not be doing immunizations or, testing for diseases if you cannot get your prescriptions filled or if you can't sufficiently staff the store. I think it's something that's going to come more. Dr. McCray, I'm sure you guys know input as well.
We've had requests from companies that want to know if they're requiring their technicians to be licensed to test for COVID, but they're not actually doing technician duties. And if people are hearing from the pharmacists that the pharmacists are short technicians, but they have these technicians over here that are doing other duties and not tech duties, and it's creating staffing issues and problems in the store, backlogs. We have complaints from a couple of stores that are 3 and 4 days behind on filling prescriptions, that they have 250, 300, 400 prescriptions sitting in a queue that the pharmacist doesn't have time to get to. But because they're having to give vaccines and testing and that type of thing, they're ending up short staffed, as well as some other reasons, some financial issues as far as rate paying. But we're getting a lot of complaints about some stores that can't staff, understaffed, et cetera, and it's affecting patient care.
And then when some of the stores are closed for a few days, people want to have their prescriptions transferred or filled somewhere else, and that store can't get to it for 3 or 4 days. So they said, we've got our own patients that we're 2 days behind on. So it's just.
Not to mention, who do they call for a transfer?
Well, and they call for a transfer, and they said, well, when we try to run it through, or they call the doctor and get a prescription. Well, it's already run through at that other store, but I can't pick it up. It's already filled
It's
somewhere
already
else.
been- We have inspectors that are seeing, days worth of drug orders in the floor, 1,000 prescriptions in the queue. I know has been seen, each patient comes in, well, I called this in, I'm sorry, we're 3 days behind on the queue. I know Dr. Krause has brought this up several times in the past, these programs that do auto fulfillment for patients, something we're gonna start doing in cases, we have complaints on this, is looking at how many return stocks did you have? And were these actually specifically ordered by patients, or was this part of an autofill process that added in extra workload for the pharmacy that the patient apparently didn't even want? If they didn't specifically ask for it and then it got returned to stock, well, that was extra work nobody expected to do.
And sometimes the auto fill is an opt-out, not an opt-in. So when you sign up here, it says auto fill, and you're getting it, and you have to actually physically opt out of it, which shouldn't be the case.
So, and I will admit that sometimes it's really hard in this chair to remember that, like, we serve not the pharmacist's best of business interests, but we're here for public health. But I think we're reaching a point, or have long since reached a point, where the mental health of our pharmacists and the workload that they're expected to do is impacting public health. But I'm not really sure sort of like what to do with that, other than maybe to start with, can we like get with the association and find out, do they have, like, is there a specific recommendation from them on what as a board we can do to help?
I know they're discussing it as well.
Sure.
There's some conversations going to try to help with some of that it's not my project
Right.
to speak on, but I can tell you there are some things behind the scenes going on that. We have thousands of pharmacy technicians that are permanent with us, and pharmacy technicians are the lifeblood of keeping the normal operation of pharmacy going. But I have personal friends that are telling me they're short, 100 tech hours a week. I don't mean a month. They have 2 techs a day, basically full time, that they can't even get someone to work it. We're doing our best to help expedite the processes for applicants coming in as well. We've got some of our live scan fingerprint technology where we can turn around some of these applications and emergencies in 2 or 3 days. People have clean records and all their paperwork.
Dr. Kraft?
Yeah, I mean, I was just thinking and listening, but seems like to me, these are going to have to be handled on a case-by-case basis. I mean, some are going to be worse than others, but the 40 hours a week, I don't know how it's termed in our regulations, but we might seek to employ a 40-hour per week during daylight waking hours as deemed appropriate by the board or something like that. But because being open 40 hours a week at night may not service your patients. I don't know, maybe that's something that we need to consider. But the the transmitting of the claim when it's not ready for the patient to pick it up. Now that's something we've really got to think about as well, because I mean, if it's not going to be filled and ready for the patient to pick up for days, why is it run? I don't understand that. I mean, I do, but I mean, from a practical standpoint, I don't.
Well, and I think part of that is we hope to all be here tomorrow. But if the water pipe bursts in front of the building again, they're going to tell us we can't come to the building. But in this instance, these companies want to be open, but they just don't have a human to go open. It's a weird thing. So, I mean, I will take there have been a couple that have done some slight adjustments to hours. But we aren't seeing any that are trying to justify their 40 hours a week or overnight, but we do have some that are discussing, or we're hearing anecdotally, bringing in a night shift crew when the pharmacy is closed to the public just to play catch up. If there's a few hundred prescriptions in the queue, can we bring in a crew overnight, close to the public, but then operate the pharmacy to catch up? I mean, we have no problem with that. I mean, it is a temporary advantage on catch up, but our biggest concern is when you have consistent open hours advertised to the public that's trying to pick up their medication and they can't get it. So we've had discussions about, when you call, there needs to be something on an automated phone line that says this location is closed today, you can get service at such and such location, there's another one nearby. Because early on, we had some that it would put us on hold, even here for the board office, and we would just sit on hold. And then we find somebody else, and they go, oh, I'm sorry, that store's closed today.
Well, they're sending out, if you order your prescription today and it's ready, it sends you an email that says your prescription will be ready tomorrow at 10 o'clock. So then you go to the pharmacy and the pharmacy is closed. You got an email that says it's going to be ready, but then when you go, there's nothing there.
Yeah, we know of 4 stores closed today.
So the reading issue is just technician labor.
No, it's also pharmacist labor. Like they don't have a pharmacist to open the store. And some of these companies are offering big sign-on bonuses and everything else. And a lot of the other discussion is, well, I understand what you're doing to get somebody, but what are you also doing to keep the people? Because if you, if I've been working somewhere for 5 years and the new guy gets a big bonus, if he'll commit, well, if I cross the street, I get a big bonus. And it's not good for continuity either. It's a mess that you guys need to know about because you're going to get hit with it just like us. And we're asking for, what's the plan of action to get this open? But as we've got at least a couple that it's happening repeatedly. And we're suggesting maybe you should alter your hours because you just can't be open that many hours. Maybe you need to turn away customers. Once again, same thing I said. Maybe you need to quit trying to worry about flu shots or COVID shots and do what your base business is.
So,
I was just going to ask, are these areas of the state where it's hard to recruit to? Or these areas of the state that traditionally have not had?
They're larger cities. It's not tiny rural cities.
so obviously, as a board, we can't patient choice, where we never refer people to specific pharmacies. But if there are, I'm just wondering, to give patients that are calling with complaints some way to something, can we refer them to the association? The association have a list of member pharmacies that potentially do have bandwidth
Well,
to
it's,
take on new patients? Like, how can we help?
we will tell them what other pharmacies are in the area. What we're asking the pharmacies to do is to also direct patients to who can take care of them. If you've got 3 stores in the area and A is closed, the patients need to know how they can get service from B or C. And if another pharmacy is trying to help that patient and it's an insurance claim, then someone at B or C should be able to reverse that insurance claim. We have a whole other process. Like, you don't need to be closed during your normal hours and unable to reverse claims.
Yeah, but this is a, public, safety issue, the people have to get their medicine. So,
John, when you talk about, recommending maybe you to modify the hours, that's still maintaining 40.
Yeah, still maintain 40 hours.
Maybe not being open until 9 o'clock. Is that an older situation?
I mean, if they're gonna advertise their hours that are open and patients see that, I'm fine with whatever their hour call.
As long as they, minimum working ways.
Yeah, which the board hasn't discussed giving waivers for just full line retail, unless it's a town that has no other service.
and actually, it's not a bad idea to, close early.
Right.
So that you can catch up, so you're not having to deal with someone like, say, at the window, at the drive-through, all you're doing is strictly filling prescriptions, either close early or come in early, to have that time to get that done.
Well, if it continues to happen, we'll have corporations in front of you to discuss it.
Dr. Kraft?
Yes, I think also, board staff might consider, how many of those prescriptions, the actual inventory to fulfill that prescription is there. Is that an issue that you know of? Because I know,
That's,
you know,
that's not an issue. It's not that they don't have the drugs to fill it, it's they don't have the humans.
well, I'm just saying, I know that, like, you know, the average brand name drug out there, is pretty expensive now. You know, it's $250, $400 for the pharmacist cost. And, you know, if you're going to get, let's just take Medicaid, which is, you know, pretty steady in reimbursement. You're looking at, let's say, $10.50. Well, you know, you're going to have that $400 drug, or in most cases, it's $1,200 drug. I know of a $3,000 cystic fibrosis drug taken by Medicaid patients. You're going to get $10.50 on, or you're going to have that sitting in your inventory for 29 days, 30 days until they come and get it. You see, so from a business standpoint, it behooves them to not order that until they get, you know, they want to get it as close to when they get that check for reimbursement as possible. So that I would wonder if, in some cases, if it's not just staff, but it's staff waiting to order certain things because of.
We've heard nothing to that effect.
Okay.
Did you guys have anything else you need to come back after lunch?
What are y'all having?
You don't want to know
Yeah,
Ribeyes,
No.
fried fish?
free leftovers.
Well, I hope y'all get fat.
Yep.
All
I
right,
don't have anything else for today.
I don't have anything else, and I don't think staff, anybody has anything else, so if the board has nothing else, then
do we have a straw poll, who can be here in November for informal?
not yet. I just said we get forward, if y'all just look at your calendars and just Before, I mean, at least four, if 4 or 5 are available, just email me. But
I think I've been DC that week for.
Talk about
we usually never had an issue with getting enough, so I just, like I said, if y'all look at calendars, it's that 8th night, it's a Monday, Tuesday this time. We had, I don't remember why we sent it on Monday, but there was a reason.
Yeah, there's a scheduling conflict.
So, yeah, if a company, like I said, if you can look at your calendars at 8th and if you have to let me know if you're available, we'll decide in a couple of weeks. We sent out all the notices, in person or virtual. So we just see what the board wants to do, but everybody's been notified that it might be one of them.
All right, do I have a motion to adjourn?
Motion.
Second?
Second.
Any opposed? Okay, we're adjourned.
Thanks, everybody.
Bye, guys.